We'll try and let you at least do one of the 5 stages with smiles.
So I'll start with the first one,
Yeah.
which is that the appellant's brother didn't enjoy rights under the directive in Italy, and so whatever Italy did, it didn't issue a residence card under Article 10 of the directive. So this is addressed in our skeleton at paragraphs 37 to 38. To make this proposition good, can I ask the court to turn up the Nunes judgment at tab 11 of the Authority Fund, page 514. This is a decision of the CJEU. Different issue to the one in this case, but we'll just look at the facts briefly. So page 531 in the judgment, paragraphs 14 to 16 set out the facts. So what happened was that paragraph 14, page 531, Miss Ormazabal was a Spanish national and she moved to the UK to study. So she started off exercising a right of free movement, and then she lived in the UK since 1996 and had worked since 2004. And then what happened was she naturalised in August 2009 as a British citizen. So at this point, she's someone who's historically exercised free movement rights, but she's also naturalised as a British citizen. She then begins a relationship with a third country national who'd entered the UK illegally, and says, well, I'd like my family member rights now, please. And the UK says, well, you can't have them anymore because you're now British. So that's what this case was about. So the court essentially asks itself 2 questions. The first question, and the only one that matters for our purposes, is whether she had a right under the directive. And the consideration begins at paragraph 37. The full passage is paragraphs 37 to 42, and perhaps I could just invite the court to read that. So essentially, although she did originally reside under the directive, paragraph 39, once she naturalises, that changes the legal rules applicable to her. So she's no longer a beneficiary of the directive, and the directive no longer governs her residence. Now, of course, this case is different because there's no suggestion he was ever anything other than a third country national in Italy and then Italian. So his situation in Italy has never been governed by the directive. The brother. I should just make clear that the position isn't any different where, as you would expect, where extended family member rights are concerned. And if authority for that proposition were needed, it's in Banger at tab 14.
Sorry, can you give me the proposition again?
So essentially, this is the position because it applies to the sponsor, in other words. It isn't any different where extended family member rights are concerned. The directive still doesn't apply to somebody who's residing in their state of nationality who wants to assert extended family member rights. I suspect authority isn't needed for that proposition because one's looking at the person who is the sponsor, the EU citizen, but that was the scenario in Banger.
Do you want to just give us the paragraphs then, rather than...
Yes, it's at... So Banger is at tab 14, and the paragraph 23 to 26, with the key passage being at the end of paragraph 25. Now, just for the court's information, but not relevant here, in both of these cases, what the Court of Justice does is say, well, the directive doesn't apply, but for other reasons, the person actually enjoyed a directly effective right under Article 21 of the treaty. That's because in Lunez, she had previously exercised the right of residence. That's, of course, not the case here. And in Banger, it was because you can assert rights as against your state of nationality. If you go to another state and work, and then you want to bring your family members back with you. So, again, that's not this case. So it's called the Surinder Singh right.
You and I have been there before.
We have, yes. So that's what happened in Banger. What they said in Banger is there's no extended family member right under the directive, but the directive applies by analogy, essentially because in Banger they'd gone off and worked in another member state and he was bringing her back with them. Those things don't apply here. So the short point is the appellant's brother didn't enjoy any rights under the directive. So where does that leave us? We've got the Italian residence card. We've seen what it's called. We note that it doesn't actually mention the brother. It's perhaps shrouded in mystery. We don't really know why Italy issued it. There are two possibilities. One, Italy's domestic legislation is just more generous. They just say, well, actually, that might be what EU law says, but we're going to actually be more generous and we're going to let all our home state nationals as well bring in their extended family members. And it could have done that under its domestic legislation. We don't know what it did. Either that or it made a mistake. The point is, it doesn't matter here because, and I don't want to give my Lady Justice Whipple nightmares remembering this, but your ladyship will recall that we had this debate in Fairtrade that if a member state does something more generous under its own domestic legislation, that doesn't mean that it's doing something under the directive. So we did bring copies of Fairtrade into court. I do rely on those passages. I can hand it up. I've given Mr. Malik a copy. But essentially, I can give the paragraph numbers in Fairtrade. We've sided on them. What if a member state decides to do something more generous that is outside the system of the directive? So the reason I'm saying that is just because Italy produces that, calls it whatever it wants to call it, it doesn't mean that it's done it under the directive. It hasn't. So Fairtrade, the relevant paragraphs, and Fairtrade was about a separate issue, but what it does is it cites the relevant authority of the ECJ, which makes that point. So first of all, paragraph 48. There's a reference there in paragraph 48 to a case called Ziolkowski. And that one needs only to read the 4-line summary at E, because that was the holding in Ziolkowski. The existence of national provisions which were more favourable to the applicants was permitted by Article 7 but didn't form part of the system introduced by the CRD. And then that is explained in more detail by the CJEU again in the case of CG. Paragraph 53, page 185 of this report. Could I just ask the court to read the sideline passage? The summary then of the position is at paragraphs 55, 2 and 3, which we adopt. Particularly 3, national rules can be more generous than the EU law system, but if a member state introduces a national rule that is more generous, that rule remains a rule of domestic law and is not incorporated into EU law. And then finally at paragraph 96, this was then a question about the withdrawal agreement, but the first sentence of paragraph 96, the argument there was that by granting leave under the EU settlement scheme, what the Secretary of State had done was confer a right of residence under the withdrawal agreement, and the answer for various reasons, including the one at paragraph 96, is no. Domestic law rights can't be imported into the EU legal order by one state acting unilaterally. So we say whatever Italy was doing, what it certainly wasn't doing was doing this under Article 10 of the directive. So that was my first proposition. The second proposition is a separate one, and now this assumes, because the appellant, we say, falls at that hurdle. But assume a different scenario. Assume that the appellant's brother had been a French...
Sorry, falls at that hurdle. Why? Because that shows no EU law. There's no right.
My learned friend is relying on Regulation 29, and if one looks at Regulation 29 and the definition of a qualifying EE state residence card, this is one reason it fails. It's a residence card issued under Article 10, and this one wasn't. There are other reasons his reliance on Regulation 29 fails, but that's one of them. But also, at one stage in this case, and I think it's been abandoned, there was an argument that he did have a right of entry because of this Article 10 residence card, and I'm about to say why that's wrong. And at the same time as doing that, just make some fundamental points about the Article 3.2 right. So this second part is to deal with why the appellant had no right of entry under EU law and the directive, and we do say that's relevant. First, because it's the context against which the withdrawal agreement falls to be construed. And second, because to the extent it's still lingering as an issue, it needs to be stamped on in my submission because it's just wrong. So this appellant fails because there was nothing issued under the directive. But now imagine a different scenario. What happens if a French national living in Italy grants that French national an extended family member card? Can that person say, right, thank you very much, here you go UK, Italy granted me one, so you need to let me in as an extended family member? And the answer to that question is no, for reasons that I'll now explain. So there were essentially 2 points here. The first is to show in principle why the directive wouldn't have provided that having an extended family member right in one state would lead to you having a right to enter another state. And second, I'm going to show you not only would it have been incoherent to do that, but it didn't do it. So could we start, this is addressed in our skeleton at 23 to 36. I'm essentially just going to explain what's there. 2 authorities on the nature of the extended family member right, and I do want to show the court Rahman, because this is and I'm mindful that my Lord Justice Lewis knows it very well, but this is the case where the CJU tells us, what is this extended family member right? Because it's a new thing. And this was a reference from our upper tribunal. So the judgment begins, I am going to go back to the Advocate General for a specific reason, but I want to start with the judgment. So the judgment begins at page 466. And just to note while we're here, the legal context, that the court refers to certain provisions in the directive. It refers to Article 2.2, Article 3 and Article 10 on page 467. What it doesn't do is refer to the residence rights and the right of entry, because it's about to tell us that extended family members don't have those rights. Article 10 is there. We say Article 10.1 is significant, so while we're here, let's look at it in paragraph 6. The right of residence of family members of a union citizen who are not nationals of a member state shall be evidenced by the issuing of a document, shall be evidenced by the issuing of a document. And as Mr. Malik pointed out, in Article 10.2e, this is one of the occasions where the directive, when it says family members, means extended family members. And we know from Banger, because the court tells us, that the directive is a bit inconsistent about when it uses the term family members. But this is a clear example of family members meaning extended family members. So Article 10.1 is saying that including for extended family members, you have to evidence their right, you must evidence their right by the issuing of a document. But we know, where does the right come from? It comes from domestic law, and we're about to see why that is. The facts are at paragraphs 11 to 14, and again, I just wanted to show the court the facts because this is how it works, and it's of interest, at least in this case. So what happens, paragraph 11, page 469, on the 31st of May, Mr. Rahman, a Bangladeshi national, marries an Irish national working in the UK. And then following that marriage, his brother, his half-brother and his nephew apply for EEA family permits in order to obtain the right to reside in the UK. Those applications are refused. And then what happens is that there's an appeal, paragraph 13. So, and this is the way the court describes it. The immigration judge allowed their appeal on the 19th of June. The immigration judge found that they're entitled to benefit from the provisions of Article 3.2 and that therefore their entry in the UK had to be facilitated, their entry. That's because they were applying for EEA family permits. I'll show the court the regulations, but what the EEA family permit does is it gets you to the UK if you're not already here, and then it expires.
Yeah.
It works. It isn't quite an entry clearance, but it works like an entry clearance because while you have it, you're treated as a family member and then you can come in. It was only valid for 6 months. The expectation was that having got here with your EEA family permit, you then apply for a residence card. So what happens is the Rahmans come under their EEA family permit, which is described as facilitating their entry, and then they're refused residence cards. They're refused the right to reside, and that's how it all ends up in the ECJ. So the key passage as to what the right actually is at paragraphs 18 to 26. And apologies, I think by mistake the Advocate General has been sidelined rather than the judgment, but the key passage is at 18 to 26. The court might want to read that in its own time. Could I just pause for now on first of all, paragraph 19, which says there's a distinction between the two types of family members. But can I then just invite the court to note that there's a reference here to the recital to the directive and to read that recital. So the important words in the recital are on the basis of its own national legislation. And I'm going to come back to that. Then we get the breakdown of what the right involves, and it's a slightly odd right. What it gets you, see paragraph 21 at just after B, it imposes an obligation, doesn't oblige the member states to accord a right of entry and residence, but it does require them to it does require them to confer a certain advantage on applications. What is that certain advantage? Make it possible to obtain a decision on their application that's founded on an extensive examination of their circumstances and, in the event of refusal, is justified by reasons. And then we get at 24, each member state has a wide discretion as regard the selection of factors to be taken into account. Nonetheless, the host member state must ensure that its legislation contains criteria which are consistent with the normal meaning of the term facilitate and of the words relating to dependence used in Article 3.2. I'll come back to that, but the court may recall that Article 3.2 talks about dependence in the state from which the person is coming. So what the Advocate General says is, well, you couldn't sort of make that pointless by saying you need to have been dependent for 20 years. That's an example of what the court's talking about there. And then here, not sufficiently precise to enable an applicant for entry or residence to rely directly on Article 3.2 in order to invoke criteria which should be applied. So not only do you not have a direct right of entry and residence, you don't even have a directly effective right to say these are the criteria which should be applied when assessing my application, but you are entitled to a judicial review. And then it's all captured in the dispositif at paragraph 26. Perhaps the court would just like to read paragraph 26. So at this point, what we see is it's fundamentally different from normal EU law rights of residence, which means you just turn up. In the old days, when we were still in the EU, I could just turn up in France and start working, don't need anybody to give me permission, and I have a right by virtue of doing that. This is fundamentally different. What the court's saying is that there has to be a decision in your favour. You can't just turn up and start exercising rights. And plainly, and we've seen it from Article 10.1, that decision, which is a decision under national legislation, will be evidenced by a document of some kind. And we'll see under the domestic legislation that it does have to be. There does have to be a document for you to have the right. Now,
Is a more accurate way of putting it that EU law leaves it to national law to determine whether, in what circumstances, is subject to what evidence, an extended family member's right of entry?
yes, and there's a good example of it that I can show the court in question 6. So question 5 is about whether the state can impose particular requirements as to the nature of the dependence referred to in Article 3.2, which is dependence in the country from which you have come. But the upper tribunal in this case had a 6th question, which is can the host state also say, I want you to be continuously dependent here? Because that's not in the directive, and that is what the UK requires. So the upper tribunal then asked this 6th question, and that appears in paragraph 41. Can issue of the residence card referred to in Article 10, that's obviously for EFMs, be conditional on the requirement that the situation of dependence has endured in the host member state? What does the court say about that? It effectively says, well, it's not any business of ours because the directive doesn't deal with it. So that's at paragraphs 44 and 45. Perhaps the court would just like to...
Can you help me, because
Yes.
it's here. Where are the pieces of Rahman that really say it's got to be a decision that's got to be documented, as opposed to it being discretionary and national? Have we got there yet?
Yes, so the document comes from Article 10.1, and certainly under UK domestic... Article 10.1 says it shall be evidenced by a document.
I see, okay.
But of course, there has to be... If it's... Because it's different from the EU law, right, where you can just turn up, you've made a decision, it's got to be... Just the way things work, it's got to be documented somewhere. There's got to be a decision.
I think we maybe across purposes. You can be required, the member state is required to provide a document because that's what Article 10 says. But if you've got a national law decision that says you're allowed to come, and if the national law decision says shall be in writing unless waived by the relevant authority, that would be enough for national law purposes. You might also be able to insist under Article 10 that member states give you a residence document, but as a matter of national law, it's for the national state, surely. It's not for the European Union to say that the domestic law right must, as a matter of domestic law, be granted in a written decision.
No, but in a sense, it does say that in Article 21 because it says shall be evidence. But the point, I think, is more that given the nature of the exercise that has to take place, given the need, for example, for reasons. So if one looks at paragraph 22, if it's refused, justified by reasons.
22 of what?
22 of the judgment.
Rahman.
So a refusal certainly would need reasons. I accept that's not the same as a grant, but...
Sorry, I've lost the time now.
I'm so sorry.
To obtain a decision on their application.
Yes.
Okay.
So the state has to go through a decision-making process, but the reality is, because it is a decision under national legislation, it's got to be recorded somewhere.
Why? As a matter of domestic law?
Well, as a matter of domestic law under the 2016 regulations, it does.
Yes, that's different. It doesn't have to as a matter of EU law.
Well, if that's
the point I'm building up to is this: even if you hadn't got round to issuing your residence card, and goodness knows, it's unlikely, but maybe the Home Office doesn't do it, you'd still have your EFM right into domestic law, even if they'd never got round to issuing the article.
Not under domestic law, because you don't have it until you've had the thing issued. But under, I take...
We are cross purposes.
I'm sorry.
I'm just talking about, you keep saying EU law requires. EU law doesn't require the EFM to be valid as a matter of domestic law only if it's in writing. Surely European Union law leaves it to the domestic law to decide whether, as a matter of domestic law, it's granted and what it's evidenced by.
Yes.
If you want an EU residence card and you want to insist that member states give you that, then you go to EU law. But it's not right, surely, to say that EU law requires the exercise of national discretion to be done in a particular form as a matter of domestic law.
No, that's right.
Yeah.
That's right, yes. But I think my submission is perhaps more in particular, and it's certainly what the Commission thinks, and I'll show the Court the guidance that the Commission in its withdrawal agreement guidance says if there's been a discretion under Article 3.2, there'll be a document. And certainly Article 18 proceeds on that basis because it just makes sense. But I accept what your Lordship is saying. So the point about this question 6, and the reason I showed the Court, is it's a concrete example of what your Lordship asked me, which is, well, what could the Member State do this? Could the Member State do this? The UK does require people to be dependent on an ongoing basis. That's just up to the Member State, says question 6. Another state might not. Another state might be quite happy. It might have no requirements. And the point I'm making is what this underlines is you can't have a situation where a state that's more generous, so for example, say Italy says, well, we don't care about dependence, we don't even care about having the relationship. It then issues the person with an EFM document that then binds another member state.
No.
That's the point.
Yeah. Your simple point is an extended family member does not have a right to write from EU law.
Yes, and
to residence in another state.
Yes, you can't impose that on another member state. And just for completeness, can I just show the Court a passage in the Advocate General's opinion? So paragraph 52G at page 455. The Advocate General, not all of this opinion is accepted, but what the Advocate General says about the right, the nature of the right is fundamental accepted. It doesn't matter for these purposes. But at 52 at G, he makes the point that the words of Article 3.2 says in accordance with its national legislation. And it's just relevant to note, as he points out, that provision in Recital 6 is actually introduced by the Council because they are so concerned to make it clear that this is about national legislation. And that simply underlines my point that you can't have a situation where one state is bound by another state's decision under its national immigration legislation. And that's acknowledged just for the Court's note by the Advocate General at paragraph 64E, says you're going to have differences between states. The other case I wanted to show the Court is a Bangby, because it shows that the upper tribunal did get this wrong, and that insofar as Mr Malik's case is that extended family members enjoy a right under Article 6, they don't. So a Bangby is at tab 12, I'm probably not pronouncing it correctly. The facts, it begins on page 540. It's a decision of this court, Sir Stephen Richards giving the leading judgment. Facts at paragraphs 1 to 2, essentially the applicant is trying to establish a right of permanent residence, and what he wants to do is rely on a period when he satisfied the conditions for being an EFM, but when he didn't actually have a document. So this is a case about the 2006 regulations, but for present purposes they weren't materially different. And this case decides, in effect, that substantive residence rights are enjoyed by family members, but not extended family members. So, paragraph 23, the case advanced by the Secretary of State is correct. And then paragraph 24, substantive rights of residence conferred by the directive are enjoyed by family members as defined in Article 2.2, but not by extended family members as defined in Article 3.2. And then at paragraph 25, what is it? It's just the obligation in member states is a limited procedural right. That appears third line of paragraph 25. There's then a citation of Banger which I mentioned earlier. And this is the case where the ECJ says, well, yes, actually the directive isn't very consistent about the way that it uses the term family members. So there's a passage cited from Banger at paragraph 29 on page 459, and then at paragraph 46, and this is from the CJU in Banger, the concept, as the Advocate General observed in point 87 of his opinion, and point 87 says it's used inconsistently, the concept of family members is used in other provisions of the directive, and it mentions there Article 10 and Article 5 and Article 3.2. So what the court is doing in citing Banger is saying, yes, but it's not, what it's not doing in Banger is telling you that there are any other rights. And so therefore at 30 and 31 you get the procedural rights, and then at 31 the right of permanent residence conferred by Article 16.2 on family members who meet the specified conditions is a right only conferred on family members as defined in Article 2.2. So that is effectively a decision of this court which says extended family members do not enjoy the residence rights in the directive, and that obviously includes the 3-month right of residence. I just want to, while we're here, show the court a passage which, that there are various cases of this court that have said it, which is that you're only an extended family member after residence documents have been granted to you and not before. That's a proposition that's set out in paragraph 16.2 of our skeleton. It's made good by the long passage at 34 onwards, which cites a different case of this court called Macastana, but I can shortcut it for the court by just perhaps inviting the court to read a passage in an upper tribunal decision which is approved at paragraph 38.
It's always so much more helpful to look at the regulations and what they say,
yes,
rather than to look at not even the case about the regulations, but a case which has a bit about it as a case.
Yes, the reason
very difficult to give any real meaning unless you look at the regulations or look at that whole thing in context.
Which we are coming to. I don't think that's a proposition in dispute, but if it is, we can do it more slowly, and we can go to Macastana, which is at tab 13.
Because it's not clear to me how significant this is in this case anyway.
It goes to my point, I think, that under the domestic scheme, you can't be an extended family member without issue of one of the stated documents in the regs. But
yeah, I'd like to see that. I would have started with the regulation. I wouldn't have started not even with the case, but with a paragraph of the case in another case. So it doesn't matter for you.
Well, the reason I'm doing that is because we're in that case for different reasons. So I thought while we were there, but we can certainly come back to it if that's helpful. So let's turn then to the directive.
So is this stage 2 still, or are we on stage 3 now?
This is still stage 2. This is about EU law still. So turning to the directive, Article 5, let's just deal with Article 5, rights of entry. So that is on page 131. Now, I don't think there's any dispute about this now. The short point is that Article 5 just doesn't apply to extended family members.
And the first reason of the upper tribunal judgment, I think, is accepted to be wrong in that sense.
Yes. So when it talks about family members here, it's talking about direct family members. Why does it refer to Article 10 though? Because extended family members can also have a document issued under Article 10. Well, it does, but the bit of it that refers to Article 10 is only relevant to direct family members.
Such family members, yeah.
Yeah, so to give an example, the spouse of a German citizen working in France, when they return to Germany, is an example. Or the spouse of a German citizen working in France, So it works. So it works in two situations. So you can use that Article 10 as against your member state of nationality, but also if you're a German citizen working in France and you go on holiday for 3 months to Thailand, you can then also rely on it as against France. What you can't do is rely on that if you're an extended family member, because you don't enjoy the right in Article 5.
We're just looking at the words rather than the example. Is it right to say that 5.2 says family members, and that is family members as defined in 2.5, because the other ones are beneficiaries under the directive, not things. And then your point about Article 10 is really shall exempt such family members, and that's the reference back to the family members of the Article 2.5.
Yes, and this isn't one of those provisions where extended family members means something else. The other point about Article 5 is that this court has said in a case called Core that all it is a procedural provision for those who already have the right of entry, the right of residence, sorry. So the reference for that is Core, tab 16 of the Authorities Bundle, paragraph 50 sub 2.
So stage 1, the brother didn't have any Italian rights. Stage 2, even if he did, and even if the appellant was an extended family member of the brother, and even if he had an Article 10 residence card, he still didn't have any rights under EU law to come in.
Exactly, because you can't have one state dictating to a second state who can't enter.
Right, so that's as far as we've got.
Yes, so now we're on my third section, which is 2016 regulations, at long last.
Yep.
So,
I'm very keen on the regs, as you know.
Well, that's fair. I shall remember that the next time I'm preparing. So we address the regs in our skeleton at paragraphs 15 to 18, and then at paragraphs 40 to 44. So tab 4 of the bundle. Can we start in the definitions? Now, I should say I just realised at lunchtime that these are the original version of the regulations and not the version as in force as at the date of the decision.
Right.
We've done a scan to try and see if there are any differences. There are some. They are not necessarily material apart from one that the court might be interested in. We will, of course, get those to the court.
Yeah, because we might put in other things which we might think are relevant and you may think not, and they could be wrong then.
Exactly. So we will certainly do that, and I've mentioned that to Mr. Malik. Where I've picked up a difference, I will tell the court as we're going through. So Regulation 2 is definitions. 166, an EEA family permit there means a document issued under Regulation 12. We're going to take a look at that. The court's already seen qualifying EE state residence card, but I just want to pause, and this was why I took EU law first, to say why we say it doesn't bite here. Qualifying EEA state residence card means a valid document called a residence card of a family member of a union citizen issued under Article 10 of the directive. Well, it wasn't issued under Article 10 of the directive in this case for the reason I've given. But there's other reasons why it doesn't bite. As applied where relevant by any EE state to a non-EEA family member of an EEA national as proof of the holder's right of residence in that state. So 2 points there. First, family member. We're going to see that family member only means an EFM if they have one of the relevant documents. So where it says family member in qualifying EEA state residence card, what does that mean? We need to look at Regulation 7.3 for that. So those are the definitions, and residence card the court's already seen. Regulation 7.3 then, the way that it's done under the EEA regulations is by a fiction, you become a family member. So Regulation 7, page 171, it is addressing family members. Regulation 7.1 deals with direct family members. Then there's a special provision for students, and then we get Regulation 7.3, this has been amended, but not in a material way for present purposes. So here, a person B who is an extended family member, who's an extended family member, see Regulation 8, and has been issued with an EEA family permit, a registration certificate or a residence card, must be treated as a family member of A. So that's the crucial bit. You've got to have been issued with the thing. And then, on top of that, you have to continue to satisfy the conditions. So it's not good enough just to have the piece of paper. And the EEA family permit, registration certificate or residence card remains in force. So that might be a better point to just look at the decision in Macastana. May now make more sense. Macastana is at tab 13. So, facts at paragraph 2. So, what Mr. Macastana does is he enters the UK unlawfully, and then he subsequently starts cohabiting with a Polish national. They get engaged, then they go away to Kosovo and get married, and then he's granted an EEA family permit as her spouse, and then he re-enters on the 5th of September 2008. Then, on the 30th of July, he's convicted of a serious offence, attacking somebody with a saw, and the Secretary of State wants to deport him. And he says, well, the test you have to apply to me is the test applicable to those with a permanent right of residence. And what you need to do is you need to count the time that I actually was on the facts an extended family member, but when I didn't actually have any documents. And that fails. So paragraph 7 is his argument. He maintains that before he married Miss L, he was an extended family member because he was in a durable relationship with her in accordance with the definition of extended family member in Regulation 8.5, and on that basis, he ought to be treated as if he had a permanent right of residence for 5 years. That's paragraph 7. The grounds of appeal that the Secretary of State advanced are at paragraph 14, and the specific argument advanced by the Secretary of State at D is his residence as an extended family member was not lawful residence unless the Secretary of State had been asked to exercise her discretion, and that discretion had been exercised in his favour. That had never happened. And then there's a third ground of appeal, which is that the upper tribunal had been wrong to decide that the Secretary of State had implicitly exercised her discretion adversely to him, let alone to decide that the Secretary of State had exercised that discretion on wrong principles, let alone that the upper tribunal had exercised discretion itself. So we'll see why that matters in a minute. What does the court say about all of this? Paragraph 15, last 4 lines, it points out that Mr. Macastana never made such an application, in other words, an application under the regulations. All that happened before he left for Kosovo was that he'd entered the UK unlawfully and unlawfully remained here. It's true that he told the Secretary of State that he wanted to marry her, but he didn't ask for a residence card on that basis. All he asked for was a visa disclaimer form. Paragraph 16, Mr. Macastana now argues that the Secretary of State knew of his relationship and has never contested it. That's enough for the durable relationship to be added to his time as a spouse. And then paragraph 17, that can't be right. An extended family member can only be issued with a residence card on the basis of his durable relationship if the Secretary of State has undertaken an extensive examination of the personal circumstances of the applicant. That's never happened and can only happen after an application for a residence card is made. Merely notifying the Secretary of State that one is in a durable relationship is nowhere near enough. to constitute such examination. And then there's reference to an earlier case of CS Brazil. And then at paragraph 20, there was, in my judgment, no duty on the Secretary of State to take into account when considering whether he should be deported the fact that he could have applied for a residence card and would have been entitled to an extensive examination. And then there's an argument about CS Brazil. We haven't included CS Brazil in the bundle, but it effectively says the same thing. You can't rely on time when you are undocumented.
So what's the purpose of the reliance on this case? Just to show that...
Sorry, I didn't...
So what's the purpose of the reliance on this case in the context of this appeal? Simply to demonstrate that you will not be a 7.3 exactly. family member until you got the residence card.
Exactly, an illustration of Regulation 7.3. Could I just invite the court also to look over the page at another citation from a decision of this court, which is that the tribunal can't exercise the judgment for itself unless that has been done by the Secretary of State. So that's there's a citation of Aladesolu, which is also a reference to it being a matter for the discretion of the Secretary of State. And at paragraph 25, it's not open to a tribunal to exercise the discretion for itself because the Secretary of State's got to do it first. So this is really just building on how does this regime work domestically and how has it been held to work domestically by this court. Regulation 8 sets out the conditions, and we've seen that. I should just note that missing from this version of the regulations is Regulation 8A, which sets out some factors that need to be considered when an extensive examination is required. Those include character and conduct, and whether the EU national would be prevented from exercising free movement rights. So that was added to the regulations in August 2019. I'm going to come back to Regulation 11 after I've looked at Regulation 12 and 18 because it builds on those provisions. So Regulation 12, how do you get an EEA family permit, which is the thing, if you're outside the UK and you want to come in as an extended family member, you need an EEA family permit. Could I just invite the court to read sub 4 and 5 on page 176 of Regulation 12. So when the entry clearance officer gets the application, it's the Secretary of State who needs to do an extensive examination of the personal circumstances of the applicant, and then they get the EEA family permit, if that's allowed. So that's what should have been applied for here, or it's certainly a route.
It would have been the route, yes.
It was the route under the 2016 regulations. There might have been other things under domestic law. What would have happened if one of these had been granted and they'd come in December 2019 with it, is that it would have expired 6 months later in June 2020, and then they would absolutely have needed to have applied for a residence card. So actually what's being said here is, well, we're in a better position actually, because the man said you can go. So even assuming that the immigration officer could have granted an EEA family permit at the border, which he couldn't do, still would have expired. And then they would need to have regularised their position in the UK.
Yeah.
And then Regulation 18 is how do you do that? And this is what the Rahmans applied for and what an EFM applies for if they're already here. That's Regulation 18. And just to note that Regulation 18.4 and 5 mirror the provision in Regulation 12.
Yeah.
So we probably don't need to pause on that, but and we will check again if the terms of that were amended, and we'll make sure the court has it. So now, with that in mind, we can go to Regulation 11. I think Mr. Malik accepts there's no right, but he said you can imply one into the regulation. Well, one might as well not bother having Regulation 11 if you can just imply things into it. who can be admitted, Regulation 11.2, a person who's not an EEA national must be admitted if that person is a family member of an EEA national and produces on arrival a valid passport and qualifying EEA state residence.
Sorry, I've lost the number. Which
I'm
number?
so sorry, 11.2a.
Thank you.
So this is who can use a qualifying EEA state residence card, not an extended family member, because they're not a family member unless they've been granted one of the UK's documents, see Regulation 7.3. So they can't benefit from the qualifying EEA state residence card. And as I showed the court deliberately, Article 5 and Article 10, that mirrors EU law. It's only direct family members who are going to be able to rely on an Article 10 residence card. So you can't, if you're an EFM, even if Mr. Malik didn't have the problem that it was an Italian residence card, you can't as an EFM say, well, I've got a qualifying EEA state residence card if you're not a documented EFM. And if you're a documented EFM, you don't need it anyway because you've got your UK document. Does that make sense?
Yes, I think.
So
The short point is that family member means what it says.
Yes.
It means a family member.
Yes.
The Article 2.5 family members, direct. Yeah.
Exactly. So, but
And you don't get around that by
No.
having a qualifying EEA state residence card.
No, because if you haven't got the thing that you need under Regulation 7.3, which is the EEA family,
Which is the UK card. You
Which
don't
is
move
UK.
from 7 into 7.3,
exactly.
yes.
And you wouldn't need 2A as an extended family member, because if you've got what you need, you'd come in under 11.2B 2.
Why have they put it there then?
Well, because it's for family members. Why is A there? Because somebody like Mrs. McCarthy, in a judgment of the CJU called McCarthy, who was Spanish, she was Colombian, living with her husband in Spain. He was British. The CJU said, well, as his spouse, she can rely on that residence card when they're coming to the UK. But she was a direct family member. That's why it's there. A is there for direct family members. It's not there for EFMs.
Okay.
B2, if you are a documented EFM, and by that I mean somebody who has one of the UK documents, then you're treated as a family member, see Regulation 7.3, and then you can come in under 11.2b, provided that you produce on arrival your valid document CB2. So that's the provision that gets EFMs in.
I'm glad they made it so simple that even immigration officers can understand it. Gosh, yeah.
So
Okay,
that's-
sorry, can you just unpack that? I
Yes,
haven't
of
quite
course.
got it. So I've got 11.2a is direct family members only.
Yes.
11.2b
Yes.
includes extended family members. But why doesn't it apply to this particular appellant?
Because he didn't have, so
He didn't have any of the documents in.
because
Yeah.
if I'm going to call them wannabe extended family members, means someone who hasn't granted the documents yet, they're not treated as family members under the regulations.
Right.
So a wannabe extended family member might satisfy the conditions, but they haven't yet got what they need. See Regulation 7.3.
They are an extended family member. They're not a wannabe extended family member. They are an extended family member. What they are not is a family
Yeah,
member.
wannabe family member perhaps
Yeah.
would be more accurate.
Yeah, I mean, that's the problem, is where the EU used family member and beneficiary, we've used family member and extended family member.
Yes. Although sometimes it uses family member to mean extended.
Yeah,
which
but
is
essentially the
unhelpful,
difference is between a family member and extended family member, and you stop being an extended family member, morph into a family member if you're clutching a
Exactly.
UK card.
Yes, it's the way it was done. So,
Yeah.
in answer to my lady's question, if you turn back to page 171 and look again at Regulation 7.3, a person who is an extended family member, in other words, they meet Regulation 8, and has been issued with an EEA family permit, a registration certificate or a residence card, must be treated as a family member of A. So once you get that, any time the regulations refer to family member, yes, that includes me, because I meet regulation 7.3, and that's why regulation 11.2b means that extended family members can enter.
If you've got a valid EEA family permit.
Exactly, registration certificate or residence card. But then and only then.
And sorry, just to recap the basics, this appellant didn't have those documents.
He didn't have
That's
those
different.
documents. Exactly, he didn't have those documents. So he did not have a right of admission. There isn't any basis for implying a right of admission. It certainly didn't have one under EU law, and there's nothing in the regulations which gives him one. And that's
Regulation 11, you might think, was there to do what it says in the title, to give effect and implement the EU rights. It's not at the same time saying there's also a discretion under national law. It's not dealing with that. And the fact that EU law leaves that to be a discretion doesn't mean this is the regulation that tells you what that discretion is.
Exactly, it could have done that, but it doesn't do that. Because nowhere has the court been shown a provision which says where the immigration officer decides that that would be a fair thing to do because he fancies it. So that then takes us to regulation 29. And note that this is in procedure in relation to EEA decisions. So it's not we've seen the bit of the regulations that's conferring substantive rights. All that this is doing is let me not talk. Let me look at look at the legislation. Regulation 29.1. This regulation applies to a person who claims a right of admission to the UK under Regulation 11 as a person not being an EEA national who is a family member of an EEA national. Well, that isn't the appellant. He couldn't claim a right of admission as a family member because, as we've just said, he didn't have the document.
But he is a person who might be said to be a person claiming a right of admission. You will rightly say that claim will fail, but it's not has a right, but who claims a right of admission under Regulation 11, as he is a person in possession of a qualifying EEA state residence card. It may be that he's not, because it may not have been issued under Article 10, I've got that.
Yes.
But we might disagree with you on that. We might think we've got to treat that card on its face, and we don't know whether he worked in France and then went back to Italy, for example. We just don't know anything about the movements of the brother. So it is possible, you think it's unlikely that he could be claiming a right of residence as he's in possession of a qualifying EEA state residence card. But the answer is, so what? Because all it does is make certain powers available.
That was exactly my second point. It doesn't. All it does is treat a person under 29.1 as a person seeking leave to enter, so that certain powers apply. And the court does have the provisions. I'm going to show you them.
I've got my book again.
But why does it have to do this? Because all of these people are not people who are seeking leave to enter. Because certainly I know my Lord Justice Lewis will know, and I think my Lady Justice Whipple, that there was a provision under the 1988 Immigration Act which said if you've got an EU law right, you're not a person. We've got it just as well because I'm bad at. Here we go. This was supposed to be in the bundle, but the version in the bundle is blank. Let's hand it over. A person shall not, under the Principal Act, require leave to enter or remain in the UK in any case in which he's entitled to do so by virtue of an enforceable EU right.
Yeah.
So why does the Secretary of State have to make these powers applicable?
Yeah.
Because otherwise they wouldn't apply.
Yeah.
So that's all that this is doing.
Yeah.
It's not saying, and by the way, if you turn up, the immigration officer has got a discretion. It doesn't say that anywhere. And if one looks at the powers that are applied, it's just making, so if somebody turns up at the border and you don't like the look of them and you want to detain them, it makes a detention power. So the powers that apply in the 1971 Act, as in force at the time, you can cross out 21 to 24 of Schedule 2. It's treated as if that person were a person seeking leave to enter under the 1971 Act for the purposes of paragraphs 2, 3, 4, 7, 16 to 18A. What do those do? Turn to tab A. Sorry, turn to tab 1, which is the 1971 Act, Schedule 2 begins at page 8. We can look at them. Page 10 is Schedule 2, paragraph 2. It's examining somebody to see whether they're a British citizen. This is page 10, and so on.
And that also explains why, because you're not actually, under Regulation 29, doing any more than deciding whether or not he meets the requirements under the regulations. That's why you've got the bit whether the person is to be granted admission under these regulations, because otherwise you could give him leave.
Exactly, and it's admission under these regulations, and we know that it's under Regulation 11, because that's where one finds the rules about admission.
So what's it? This is procedural, is it? This is just saying you can
Giving
check.
some powers, yeah, it's giving some powers. There's the immigration officer trying to decide whether to admit somebody under Regulation 11. It's doing what these regulations often do, which is make other bits of immigration legislation applicable, which wouldn't otherwise be applicable. And this wouldn't otherwise be applicable because these are people with rights of entry under EU law, see Section 7. So it's just not relevant to EFMs. An extended family member who doesn't have a document, doesn't have a right of admission, they can just be examined under Schedule 2 without any problems, because they don't have an enforceable right to come here. So the immigration officer who wants to examine an extended family member without a bit of paper, without the residence card or the EA family permit, can just straightforwardly rely on Schedule 2. It doesn't need Regulation 29. Just got nothing to do with extended.
A good example is paragraph 3 on page 14. One of the things you can do is examine them to find out his identity.
Yes.
And somebody may be clutching an Article 10 qualifying thing, and they may say, you can't ask me any questions, I've got the document. And they can say, well, I can ask who you are, and I would like to have a birth certificate, please.
Yes.
And I'd like to make a look to see if that photograph has been added later. That's what this is doing.
Exactly. And some other examples, C4 on page 16, it's the duty of any person examined to furnish the information.
So just go over again why it is that if somebody's got an EU law right, why do you need to specify that you have the powers under Schedule 2? Because there's something else somewhere that says, all other things being equal, they've got a right just to enter.
So these provisions are applicable to people who are, in a nutshell, people who are subject to immigration control, which means that they need leave to enter or remain. When EU law applied, there was a provision, and rightly so, to say that anyone with an enforceable EU law right doesn't need leave to enter or remain. So what the 2016 regulations had to do in various ways, and they do it in a number of ways, including they use the deportation machinery in the 1971 Act, but they have to make it applicable because it wouldn't otherwise be applicable, basically. Yeah. So, but
I mean, in two sentences, the powers were applicable for people who were subject to immigration control.
Exactly.
EU nationals weren't, and the other people weren't subject to immigration control, so you had to bring the powers back in.
Exactly. Whereas this appellant, he was subject to immigration control, so the immigration officer didn't even need these powers for him. He's just straightforwardly under Schedule 2, and you can also, under this provision, make people be medically examined. So the page references for the powers that apply, just so that the court has them, pages 10, 14, 16, 26, 42 onwards, which is detention, and then basically paragraphs 21 to 24 were removed from these regulations because they were repealed. So that's the paragraph number. So that's what we say about Regulation 29. It just doesn't do what Mr. Malik says it does. Now, as I understand Mr. Malik's case, that is a crucial part of his architecture, but it fails. So that then leads me on to my fourth proposition, which is what's the consequence of all of that I've just gone through at great length. It's twofold. It's that the appellant doesn't fall within Article 10.2 of the withdrawal agreement, and nor can he benefit from Article 18. So turning up the withdrawal agreement then, which is at tab 6, And I should say this fourth proposition is addressed in our skeleton at paragraphs 45 to 57. And the skeleton roughly follows this order. So the withdrawal agreement at tab 6, the court's very lucky it's got the whole withdrawal agreement, not just the bit of it relating to citizens' rights. Article 9, just to note, you've been shown the definition of family member, but could I just ask the court to look at the definition of host state, because that appears in Article 18(1)(l). That's on page 221. So host state means, in respect of EU citizens and their family members, the UK. And I'll say why that's relevant in a moment. And then the court's seen Article 10(2). We say if the residence has been facilitated by the host state, there will be a document. And I've explained why under the domestic regulations I say there needs to be one.
Well, hold on a moment. That's what you say should have happened, because that's what you say the rules make. But we're not dealing with the rules now. We're dealing with 10(2). And 10(2) doesn't say anything about documents. It says was facilitated by the host state in accordance with its national legislation.
And then we come back to my point that in reality, and this is certainly how the Commission sees it, that will be done through the issue of a document. Certainly in the
It's
UK,
astonishing you wouldn't in the modern world. It might be digital rather than physical.
It's still a document. It doesn't have to be a piece of paper.
Yeah.
It could still be I think the electronic things done electronically are still
Documents, yeah. So you'd expect that, because you'd expect any system, because people have got to show something. If I turned up at Berlin Airport and said, it's all right, last time I was here, Godfrey said, yes, Alan Z, or Guernsey rather, they wouldn't believe me. But it doesn't mean that it's not valid.
Well,
that's the problem.
It isn't in my submission a problem, because let me just explain what we say Article 10(2) requires. It's whose residence was facilitated by the host state in accordance with national legislation before the end of the transition period in accordance with Article 3(2).
Yeah.
So it's not enough, for example, that you've come in as a visitor.
No.
It's got to have been specific residence under Article 3(2). Otherwise, that just doesn't work. So I'm going in a moment to answer why Mr. Malik's reliance on Hassanaj and Basel. I've got 3 points in response, but just to deal with the wording first. So turning then to Article 18(1)(l), and we say it is all very interesting, as the Honourable Justice Lewis put it, whether he falls within scope. We say he doesn't, but it doesn't. He can't have anything because he absolutely falls foul of Article 18(11).
But he can't have the new resident status if you're right. But doing it stage by stage, he may be within scope, and I don't know, there may be other things he can get.
Well, there aren't in my submission, but the fact is we say that Article 10 and Article 18(11), Article 10 and Article 18(1)(l) need to be read together, and certainly Article 18(1)(l) presupposes that somebody who is relying on Article 3(2) status will have a document, which totally, in my submission, backs up the point I'm making about Article 10(2). So if we look at Article 18...
There have been some. I know that that's what you want. I can give you 2 examples of things where that wouldn't be the case. We used to have rules that said if your grandmother or grandfather had been born in this country before a certain time, or was born in a colony of the United Kingdom, they would have rights. You wouldn't have a document saying this person has rights. What you'd have is the trail of paper to show that the person was born in Penang when it was still a part of a British colony. So national law may actually build in requirements which don't involve a document, although they may involve other documents as proof of certain things. And then this country hasn't covered itself with glory. If you think of the Windrush people, they should have had documents and the Home Office didn't bother. And then they tried to get rid of them. Now, there may be situations where people are allowed, as a matter of national law, to be here, even if there isn't documents. And I don't think that would mean they aren't here as a matter of national law.
No, I'm not disputing that. My focus is specifically on Article 3(2) people. And I say under the domestic scheme, they do need a document. See Regulation 7(3). But the question is, because we've seen under Article 10(2), you've got to have been facilitated not just generally, but under Article 3(2). because this is a withdrawal agreement. It's not about everybody. It's about people who are asserting EU or EU-derived rights. So Article 18(1)L says the host state may only require family members who fall under Article 10(2) or 3 of this agreement and who reside in the host state, blah, blah, blah. The bit we're interested in is Article 10(2) or 3, and it's the bit that my Lord Justice Lewis put to Mr. Malik. For the persons referred to in Article 10(2) or 3, a document issued by the relevant authority in the host state in accordance with Article 3(2) of Directive 2004/38. So if you want to take advantage of the new resident status, you can be required to produce this. In this case, the appellant is told that, and he doesn't do it. So if you live in a country unlike ours, which has Regulation 7(3), but if you live in a country where they don't bother issuing documents, you will need one for this. I don't know that there are any, in fact. This says you will need a document issued by the relevant authority in accordance with Article 3(2). Now we say, what did the directive envisage? See Article 10(1). It envisaged that you would be given a document. And that's the thing that you need to produce if you want to take advantage of the new resident status. You've seen the letter where the appellant is told that in terms, but he decides not to apply for it. So, note just on the wording of Article 18(1)L, what is it? It's a document issued by the relevant authority in the host state, which is why I said, look at the definition of host state. So it can't be a document issued by Italy, because Italy's not the host state. And also, it has to be done under Article 3(2). So
No, in accordance with.
in accordance with.
Yeah.
So for my learned friend to succeed, he needs to expand the outcome of Hassanaj and Vaza, where there was a clear stamp saying issued under the 2016 regulations, to a situation where someone says you can go.
So the in accordance with Article 3(2) simply means it's got to be any other family member or a durable partner. That's all that means.
In accordance with, yes, so it can't, a document issued by the relevant authority in accordance with Article 3(2). So reading that with Article 18(1)L, the beginning of it, Article 10(2) and 3, and reading back to Article 10(2), recall that you have to have been facilitated in accordance with Article 3(2) of the directive, which is why I'm saying it's not enough just to have been, for example, admitted as a visitor. This is allowing you to carry on with something you've already been given.
Part of this provision is to restrict the state, the United Kingdom, from asking for lots of things which would stop people being able to stay here after we'd left the European Union. So that says you can only have these documents. You can have the identity documents, and you can have the thing that proves why you're here in the first place. That's the purpose of it. Now, if the United Kingdom, Mr. Malik says, decides to let you in on the say-so of an immigration officer, why should you be able to rely on something that's meant to stop you asking too much, to get you out of your own hole by doing it?
Well, for a number of reasons, which I'm about to come to,
right.
Because, for a number of reasons, essentially. Why? Because on the facts of this case, if we're looking at the facts of this case, the argument is in my submission hopeless on the facts, because even if he'd been granted an EEA family permit, that wouldn't have got him over the line. He'd still have needed to apply for a residence card. Indeed, he's told in terms twice before the end of the transition period to do it, and he doesn't. So whatever hypothetical situations might come to mind in terms of, well, and Hassanaj and Vaza was one. Your Lordship said, well, he stamped the thing. What's the reasonable and objective interpretation of that? That he was being permitted to come here under the 2016 regulations, and therefore that is a document for these purposes. On these facts in my submission, the same doesn't apply. So perhaps let me just explain why we say that is the case. Just before I leave the language, I've already made the point that it's a document issued by the UK, so he can't rely on the residence card issued by Italy.
That's
clear about
clear.
that. So let's just look at what the Commission has to say about this in its guidance note, which is at tab 20. What is the status of this? It's just guidance of the Commission. I'm showing the court just to show what the Commission's position is. It doesn't have any formal legal status. There's a reference in Sadiqa to somebody suggesting it could be used as a textbook. That wasn't me who suggested that, because it's not, I mean, I would accept it's not even as good as a textbook because it's been written by the Commission. It's sort of unilateral. But it is pertinent in my submission to look at what the Commission has said about this, because it dovetails with the UK's position. So page 701.
Yeah.
Article 10.2, extended family members already residing in host state. Article 10 of the agreement covers extended family members who've resided in the host state by the end of the transition period by virtue of their relation to an EU citizen exercising union free movement rights there. The duration of that residence is immaterial. The union free movement right of residence in the host state of such persons presupposes that they were issued with a residence document by the host state acting in accordance with its national legislation. The union-free movement right of residence of such persons in the host state, recognised by the host state acting in accordance with its national legislation, is evidenced by the issuance of a residence document. So the Commission certainly thinks, to fall within scope, you will have a document. Now, except...
They expect the United Kingdom to issue documents. They don't think people will be told go through. The question is, what happens if that hasn't happened?
What happens if that hasn't happened? Just as if they'd applied for an EEA family permit and been granted it and it had run out, would be that you apply for the right document, particularly if you're told to do it, in my submission. And I doubt that there's any member state of the EU that has never allowed somebody to pass through the border who ought not to have been allowed to pass through the border, is the reality. Does that mean that under the withdrawal agreement, particularly on these facts, that one has to read down the wording and say, yes, that's okay, you can have the new resident status? No, in my submission. So 3 points. First, certainly in the UK, see Regulation 7.3, facilitation requires a document. He doesn't have what he was supposed to have under the 2016 regulations, and he doesn't have any other kind of document. 2, it's not entry that is facilitated, it's residence that needs to be facilitated. So, in my submission, if one looks back at Rahman, one sees them describing the EEA family permit as facilitating entry. It's envisaging something else. How do you get your residence facilitated? You come here and you apply for a residence card. Turning in that respect to Hassanaj and Baza and that analysis, it was not, in my submission, a reasonable and objective interpretation that they were being allowed to come and reside in the UK at all, and certainly not that they were being permitted to do so under the 2016 regulations. Because...
This case, you mean?
This case, yeah. Whereas there's no stamp saying admitted under the 2016 regulations. There's nothing else to say admitted under the 2016 regulations.
But you let them in, so you must have been doing something.
Well, all sorts of things, but supposing he made a mistake, and I've given the example right at the start of my submissions about what if Mr. Chelik had been allowed in on the 25th of December 2020, because at that point the immigration officer sees Mr. Chelik and his fiancée looking very committed to one another and he thinks they're married. That would not have given Mr. Chelik any right either under the 2016 regulations or under EU law. And it's the same here. Mr. Chelik, if he'd got a stamp, that would have been different because he would have been on Hassanaj and Vaza, but there is no stamp. There's nothing.
There's no stamp, and it was difficult, and we couldn't work out, and we didn't actually decide what was the actual position of them because we didn't need to because the status had changed. But here, to put it mildly, the immigration officer had created a state of uncertainty as to what it was he meant by the words, you can go. And whatever rights, I suppose you might submit, were intended to be granted, recognised, or whatever word you use, it can't have been a right to stay, certainly after they'd been told they needed another document and they didn't.
Yes.
Yeah, that's another way of putting it.
That's my third point.
Was it?
So
I'm
that's
sorry.
the final nail in the coffin. But just still on this second point about it's not the reasonable and objective interpretation that they were being allowed to come and reside in the UK at all, let alone under the 2016 regulations. Mr. Malik says, oh, well, it must be that because leave to enter has to be granted in writing. So he can't have thought he was giving them leave to enter. But equally, one can make the same point about the 2016 regulations. I've shown that there is only a right of entry under the 2016 regulations for an extended family member if you've got the document.
The EEA family permit.
Exactly, an EEA family permit. Or you might already have a residence card because you might have come and
If you
left
come
and
before,
come
yeah.
back again. So why then pick one over the other? The reasonable and objective interpretation in my submission of what happens if one has to plump for one, if one's thinking about the balance of probabilities and what's inherently likely and not. We know the stamp wasn't used. We know he doesn't give leave to enter. Either he's lost his mind, he's had enough of his job, or he makes a mistake and for whatever reason, whether it's as to the fact or as to the law, he thinks that there's a direct right of entry. In those circumstances, we're exactly in the Petraea Diaz type situation where, okay, you've got through, but your status is still the same. And in my submission, that there's no reason here to plump for the specific construction that, well, he must have been thinking he was giving them an EFM right under the 2016 regulations. Not in my submission, unlike in Hassanaj and Vaza, where there was a stamp, and the stamp, of course, doesn't get used where you think there's a direct right of entry. So that's the mistake. It's obviously regrettable. It's clearly regrettable when a mistake like that is made, but it doesn't get Mr. Malik where he needs to get to. Now, my final nail in the coffin point is to look at the letter of the 5th of October 2020, and that's at page 218 of the core bundle. So if one looks at the circumstances as a whole, looks at that letter,
Which page, sorry?
218 of the... He's told, Mr. Malik's fairly taken you to this, on page 218, we don't have a valid family permit or residence card. And then, in order to meet the definition, you need to demonstrate that you're a relative of your sponsor as claimed and that you hold a valid relevant document. Until you hold such a document, you can't be granted leave under the EU settlement scheme as the dependent relative of an EEA citizen. If you wish to submit an application, more information can be found at, and there is, I believe, we've looked at it in other cases before this court, lots of information there about why you might need one and how to apply for one. There was certainly published guidance in 2020. So the short submission here is if one's looking at reasonable and objective interpretation, it makes no sense to say, well, the UK had facilitated his residence, because here's the UK saying, we haven't actually, can you apply for it, please? And that's my simple submission. That's the final nail in the coffin point. before I come to the fifth and final point, that's my answer on the fourth point, which is he doesn't benefit from the withdrawal agreement. Can we hand up the actual guidance that applied at December 2019? Because Mr. Malik's shown the court a 2024 version. So this is although it says updated the 11th of May 2015, it's actually pulled off as at December 2019 on the archive site, and the court will see this can't be the 2015 version because it's referring to Brexit. So unless somebody had a very evil glint in their eye, this is the.
Well, some people did, but I suspect not.
Well, they did. Yeah. So this is actually, before I take the court to this guidance, can I also just say, there was, when we were a member of the EU and during the transition period, a lot of guidance to help people about, well, can I apply as an extended family member, for example. This wasn't it, this is quite a specific thing. But if you actually look at the live version, you'll see this appellant, if he'd read it, couldn't possibly have thought that it helped him in answer to Mr. Malik's point. So look, first of all, first paragraph. An Article 10 residence card is a document which is issued under EU law to non-EEA family members of EEA citizens who are exercising free movement rights in a member state. And then it gives an example, for example, the non-EEA spouse of a French citizen who's living and working in Italy may be issued with an Article 10 residence card by the Italian authorities. So spouse is a direct family member. And then, 4 paragraphs down, there's absolutely what happened here. For example, a non-EEA spouse of a German citizen living in Germany will usually hold a residence permit issued under German domestic law. Therefore, a UK EEA family permit, or alternatively a US family permit, is required for travel and entry to the UK. So even if you're a spouse, if you've just got something under domestic law, so the Lunez point in effect, if it's just you living in your member state of nationality, can't come in with your residence card. So if he'd read this, he would have known he couldn't rely on the residence card. And then it goes on to give another example of a non-EEA spouse of a German citizen living and working in France. Again, a spouse. But it's all about direct family members, but even for direct family members, the appellant's situation is expressly excluded. And then over the page, what you're allowed to do with a residence card, it says, in order to
just read the third part. A non-EEA spouse, I think giving examples is hopeless because none of us fit into these examples, but a non-EEA spouse, so that's a third country spouse of a German citizen living and working in France, will usually hold a residence card issued by the French authorities, yes.
Article 10.
Therefore, a United Kingdom issued family permit is not required.
Exactly.
But it is, isn't it?
No, so that's the example, because they're a direct family member, where Article 5 mentions Article 10.
Yes.
So this is an example which I was explaining very badly of what's actually taught by Article 10. And then the rest of it, what you're allowed to do with a residence card, over the page it emphasises that in order to be admitted to the UK, you need to demonstrate that you have a right of admission under EU law. That's even for people with their Article 10 residence card. And then there's some bits over the page about what happens if the UK leaves the EU with a deal or without a deal. I think by December 2019 we knew there was a deal, but it hadn't been updated yet. But in any event, so this really doesn't help the appellant at all. If anything, it shows that he couldn't benefit. But I would add that if he wanted to find guidance about extended family members, there was guidance out there, and we can provide that to the court if the court wants to see it. But it's a bit of a side issue in my submission.
Can we look at the next page?
Yes.
I must say, I found the Home Office guidance very, very difficult to understand. What you're allowed to do with a residence card, now is that a UK residence card under Regulation 18, whatever it was? Because it seems to be a valid Article 10 residence card.
No, this is about when you've got one from another state.
Right, so this is still a valid Article 10 card.
Yes, exactly.
And it allows you to travel to the UK without the requirement to obtain an EEA or EU settlement scheme family permit.
Yes.
That's odd. In order to be admitted to the UK, you will need to demonstrate that you have a right of admission under EU law.
Yes, so you might have the document, but for example, you could, so there's a distinction between the procedural requirements that apply to a right of entry and then substantively whether you actually have a right of entry. So, I mean, I suppose an example might be, I don't know if I could probably with the help of my clients give an actual factual example, but you might, for example, need to show that you're actually working. So it's not good enough just to have...
I just find the two paragraphs, a valid Article 10 allows me to travel to the United Kingdom without the requirement to obtain an EEA or EU settlement. I read that as meaning I can come to, not get as far as the border, but travel to, be in the United Kingdom. And then I read the next thing, in order to be admitted to the UK, you have to have more than that. You have to have a right of admission under your law. I find it very hard to read those two paragraphs together.
I suppose you might have the residence card, but you might not turn up with your spouse, or you might turn up with your spouse, but your spouse hasn't actually been exercising any right of residence in the UK. So in other words, you've got the procedural requirements, but you also need to be able to show that you have a right of entry. So most people will have their 3-month right of entry, but they might have just had that and be coming straight back.
Leave all of that to one side. I'm just trying to read it. If I read paragraph 1, I can travel to the United Kingdom without an EEA or EU settlement scheme family permit. So if I read that paragraph and I'm Austrian, I would think I could come with my Austrian card.
I'm being told there's a simple answer if that helps your lordship. It's just what's in the next paragraph. So
right.
I'm talking nonsense, it would seem.
Oh, right.
What's it? I mean, you certainly can be asked questions at the border, but I think what it means is without evidence that you have, and then it says, well, what is the evidence that you need? And then it's underneath.
Well, what's the meaning of the first paragraph on the page?
Which one?
A valid Article 10 allows you to travel to the UK without the requirement of obtaining the family permit.
I'd have to look back as to what specific requirements were in place about travel specifically, but in my submission that you don't, what it's saying is, it's not so much that it allows you to travel, it's the next bit that follows. In other words, so let me give the example of what happened in McCarthy 2, which is a case that's referred to in court, and I can show the court this if it's helpful. So Mrs. McCarthy was a third country national, and she was living with her husband in Germany, and he was a UK citizen, and she had a residence card in Germany. And what the court said is, what the UK position was that, well, you're going to have to go back and forth to the embassy in Madrid and get yourself an EEA family permit to come here. We're not even going to let you pass first post unless you've gone and got that document. And the court says no, she can in fact use that as against the UK. She can use the residence card that's been issued in Spain as against the UK. The UK can't make her have an EEA or EU settlement scheme permit. So it's not so much the first bit in my submission, but the second bit. In other words, you don't anymore, and certainly post McCarthy 2, and I'll give the court the reference for that now. You don't need to go to the trouble of getting an EEA family permit.
It's my fault. It's absolutely my fault. I think, if I read paragraph 1, I think I can come to the United Kingdom with an Article 10 card. And I get very stroppy with the border guard if he said, no, read the rest of it. I'll say, no, I don't need to. And what you've said doesn't help me understand. It can't truly be saying, if you come to the United Kingdom, and we're not telling you this till you arrive, but you'll have to go away again. There must be some meaning to that.
It's saying, in my submission, it may be that this is something of a side issue, because we know it doesn't help this appellant for the reason I've already given along the page before. But it is in my submission saying, I'm going to turn my back in a second, you're not going to need to get an EEA family permit, and that's because of the decision in McCarthy 2. Let me just, while I'm turning my back, give the court something to do. Look at the decision in court at tab, I think it's around 16. And read at page 6 pages 638, paragraph 49 and 50 sub 1, which is what, before she was having to go back and forth to Marbella to get an EEA family permit. So that's what McCarthy 2 is about. Yes, so before we get into I was right in what I said earlier for once. There's a difference between being able to travel, because that's about carrier liability, and what questions you might be asked at the border, which is about border force. So for carrier purposes, and also see McCarthy, and also for border purposes, you don't need, if you've got a residence card in the circumstances in McCarthy 2, you don't then need to get a family permit from the UK. You can rely on the residence card that's been issued in Spain, but there is a distinction between travel and having permission to travel and what happens at the border. Now, we're getting into quite technical territory. In my submission, whatever one thinks about this guidance, if one's going to criticise it, one better look at the whole suite of guidance. Certainly doesn't help this appellant, because it says in black and white on the page before, if you're a German citizen living in Germany, you're going to need an EEA family permit or a JUS family permit, which is precisely for the reasons I've given. But
Well,
in any event,
I just don't understand what the words "to travel to the UK" means.
That's, I mean, if your lordship would like a note about the relevant travel, that it's about.
It means you can get on the aeroplane.
It means you can
no
get
one's
on
going
the
to stop
aeroplane.
getting on the aeroplane.
Nobody's going to stop you getting on the aeroplane, but
They do.
you can't get off. Well, you can get off at the other end and get back on again.
Well, you can't.
No, you can't get it if you haven't got the right papers.
Yes, the airline can stop you from travelling. And there are. I mean, there is a scheme. I mean, it's been changed recently, as I understand it. But yes, carriers can get into trouble.
This first paragraph is you can travel, so don't worry about the airline. Don't worry about them being penalised. Argue with them if they won't let you on. But the argument becomes much more serious for you when you get to the border, because although you've now been able to fly all the way from Berlin to Heathrow, that's as far as you're going to get. Anyway, it doesn't matter, but it just seems to be bizarre.
No, because you just. The Home Office is saying, yes, have the residence card, but we'd like to see that you're the family member of an EEA citizen, for example, your marriage certificate. There may be a separate question under EU law as to whether that was or wasn't permissible. The case law about it is McCarthy 2, but none of it in my submission helps this appellant. It's interesting, but the position here quite simply is didn't have any right to enter with the residence card. Mr. Malik said the court asked, well, what did he think he was doing? Mr. Malik said he looked at the guidance and produced guidance that wasn't enforced. The guidance that actually was enforced tells him he couldn't do it. It doesn't really go any further than that in my submission.
It makes it even odder that the immigration officer let him through. I mean, that's the odd thing. The one person you think would have read the guidance would have been the immigration officer, oddly enough. Well, especially since this appellant speaks Urdu but only broken English. Anyway, that's another thing. We can leave that where it is.
It is. I mean, the point is, though, that regrettably a mistake was made. And I've said the most likely, although we're all speculating, is that he made a mistake and thought he had a direct right of entry. It just doesn't get Mr. Malik's client anywhere.
Which you would have had if he was a family member.
Yes,
right?
Exactly.
So if he was a spouse or something. So that's the mistake, is that in thinking a brother was a family member when he's not.
Yes, or he got mixed up and looked at the residence card and thought, I don't know what, but he didn't. Is the long and the short of it. So the fallback point actually only rises if there is any period of facilitated residence, and of course we say there isn't. And he can't actually get over the requirement in Article 18(1)(l) to have a document, and this isn't the case for all the reasons I've given, where the clear wording of the withdrawal agreement should be ignored, and he should be allowed to get the new resident status despite not having what he ought to have done, particularly when he was told he needed to do it. But we do make the points at paragraphs, I think it's 58 onwards of our skeleton, which is that even if he did have a period of facilitated residence, it had ended by the end of the transition period. And he couldn't rely on prior historical residence for the reason we give in our skeleton at paragraph 59. Now, that has been considered by this court, but not in the context of extended family members, but in the context of somebody asserting a different type of right. Can I just show the court IULA?
I haven't really understood this yet, actually, at all. 50, and I've written on my things, why, and so on. So I haven't understood 58 to 59, and I'm still forgetting, and I did know, or I think I knew, but I've long since lost the will to live, how it was you had to have the new residence document, and why it was that you couldn't any longer rely on that thing which you'd had under the regulations. Now, the regulations were repealed.
They were.
And is that what happened? It's just because they were repealed, and I forget when they were repealed now, but that's the gap in my knowledge. I must once have known it.
I think it's the same. I don't know it off the top of my head. What I can say is, yes, the regulations were repealed by primary legislation. We can give the court a note on this, and they were prevented from taking effect as retained EU law, and that was the Immigration, Social Security and something Act.
Something Act in 2022, was it?
And then what happens is that there are quite complex transitional provisions, which your lordship was looking at in a case called Rafiu.
Oh yes, it's all coming back to me. Yeah.
Yes, and basically there were various transitional provisions. There was what's fondly known as the grace period SI, which was for people who were residing lawfully as at the 31st of December, and this appellant wouldn't benefit from that.
Yeah.
And there were some separate transitional provisions, consequential, it's often called the consequential statutory instrument. We can give chapter and verse, and that dealt with certain things like continuing to issue documents, like ongoing appeals and things like that. So
if I wanted to find one thing in an act or a regulation or a guidance which said after X date you can no longer rely on anything given to you under the regulations, you have to have an EUS scheme thing, where would I look?
And there is not, I think, just one thing. So it's a combination of various things. It's a combination of no longer having any rights under the 2016 regulations, but there's a grace period, although... So
the thing is repealed, and you've got 6 months to apply for the new thing. So that's what brings it back. It's the combination of the decapitation of the regs, but the extension period of the grace period.
But not everybody gets the grace period. So, for example, I mean... So I'd need to give chapter and verse on that, but essentially it's the ending of those rights, the new rights stepping into their place, and it's a combination of the revocation of the regs and not benefiting from the preservation of those regs by one of the statutory instruments. And so that means that if you want to be here lawfully, you can't use those old routes anymore. You're going to end up having to apply under the EU settlement scheme. If the court would like a note on that... Well,
I'm just wondering how it applies to this case, because he was refused... Which appeal are we dealing with? Which decision was refused?
The application under the EU settlement scheme.
And where's that?
That's at page 218, the first one. Of course, he's told twice in 20...
No. This is an appeal against a particular decision.
Oh, the one that he's actually appealing. That's the fourth.
And what date is that?
22nd April 2021.
It's March 2022, I think, page 156.
156.
March 22.
Yeah, so there were 4 decisions, 2 in 2020, 1 in 21, 1 in 22. So the one he's appealing against now
Page 156.
Yes.
And what was the date of the application?
I don't know. You know, Jane.
Because would it help him?
6th of January. I think we've got it actually. We've got the covering letter at page 177, which is dated the 25th of January 2022.
Hold
So
on.
that's the covering letter at page 177.
So what's going through my mind is this, and nobody's followed it through. If he applied on the 25th of January 22, and if we allowed the appeal, then the thing should have been granted. So if it still existed, if the scheme existed and the regulations hadn't been repealed on the 25th of January 2022, and Mr. Malik wins, doesn't he?
No, because he's never made that application for a family permit or a residence card. The court, I mean, ultimately he can only get anywhere if all he can have now is leave under the EU settlement scheme, and in fact that's all he's ever applied for.
Yes, that's what I'm saying.
So,
though. Say you're wrong. Say Mr. Malik wins.
Well, the Secretary of State...
Say you have the same awful experience as you had in Vassar, and we find Mr. whatever, the appellant. All I want to know is there something that's happened because of the repeal of the regulations that means it doesn't help him? But if the regulations were repealed after the 25th of January 2022, then it seems that his application, assuming the regulations was there, and presumably any application you made prior to the revocation of the regulations, do they carry on?
I think well, he didn't make an application, so it doesn't matter. I think the position would be that if this court said, in refusing this application, the Secretary of State has breached the withdrawal agreement because A, he fell within scope, and B, he met the requirements of Article 18 as we interpret them to be, then the Secretary of State would need to find a way to give effect to that in order to comply with the obligations under the withdrawal agreement. If he didn't qualify under the EU settlement scheme rules as currently framed, the Secretary of State would need to do something about that. It will... let me just check this. So I'm asking.
He did make an application under the EUSS scheme. That seems to be what he did.
Yes.
And if you unlawfully refused that, as you had done in Vassar and Assange, you'd have to give it to him in some fashion. But I'm just wondering whether it's been affected by the repeal of the regulations, whether that came after his application.
No.
So it will be helpful for him to win.
Well, yes, because under the EU settlement scheme, that's the Secretary of State's Article 18.1 residence status. Just as someone on the live stream will email and correct if I'm wrong, but the Secretary of State gave effect in Hassanaj and Vaza by a grant of leave, albeit that the Secretary of State had to construe the rules in a particular way. So if this court says, well, you've breached the withdrawal agreement, Secretary of State, the Secretary of State will find a way to deal with that.
Right,
Does that...
That helps, actually, because I was wondering if his latest application was too late, because we don't have the dates. But that doesn't matter. We got to this because I didn't understand why you're saying that the thing ended in...
What ended in December 2020 was what he needed to have applied for under domestic law, which was the extended family member route. So there's two different things. There's one, what you needed to apply for under domestic legislation to fall within scope of the withdrawal agreement, and then two, what you get if you fall within the withdrawal agreement. So to take a very simple case, supposing somebody came and applied as a durable partner in 2020, what they apply for as a durable partner is as a product under the 2016 regulations. It's one of those documents that are referred to in Regulation 7.3. They then use that as the document that they need under Article 18.1L. It's the fact that they were granted that under the UK's Article 3.2 scheme, which brings them within scope of the withdrawal agreement, and which is the thing that they need for Article 18.1L. So
you talk me through 58 and 59 then, the alternative analysis. If you lose all the way down the line, and his residence was facilitated in December 2019.
Yes. So we say, under Article 10.2, it's not good enough to have been an extended family member at some point in the past. This looks at what you were doing at the end of the transition period.
Right. Can you take me to the rules or the regulations?
Yes. So it's a combination. It's how we say Article 10.2 should be read, combined with the fact that if it's not read like that, it results in a strange outcome. So can we start with IULA, which deals with...
Oh, no, let's start with 10.2, and you tell me the words of 10.2, because I want to know what the withdrawal agreement says.
What it
Or
says,
it is 10.2 of the withdrawal agreement, not 10.2, and the words that you say there, that means that
Right,
if his residence had been facilitated in December 2019, that it ended in the transition period.
Yes, before the end of the transition period. So could we start, please, by looking at Article 10(1)(a)?
Yeah.
Union citizens who exercise their right to reside in the UK in accordance with EU law before the end of the transition period and continue to reside there thereafter.
Yeah.
The shared position of the Secretary of State and the Independent Monitoring Authority, and as I understand it, the Commission, is that that means at the end of the transition period and not at some prior point. That is live in a case in this that was due to be heard in this court next week. It has adjourned because it is being stayed behind Vargova and Molnar.
Yeah.
But
Let me just understand that then, because I haven't understood it. Union citizens who exercise their right to reside in accordance with the law before the end, you mean immediately before the end?
Immediately before.
Right.
And that was also the view taken by Lord Justice Green, albeit in a dissenting judgment, but no disagreement on this point. It just didn't ultimately matter in the case of Ali in this court. So, and as I say, the IMA and the Secretary of State both agreed in the case that was due to be heard next week that that means immediately before the end of the transition period. Could I just ask the court to look at Article 6, which is references to union law, and that says, Article 6(1), with the exception of parts 4 and 5, unless otherwise provided in this agreement, all references in this agreement to union law shall be understood as references to union law, including as amended or replaced, as applicable on the last day of the transition period, which we say supports the reading, because union law means union law at the end of the transition period.
So you look at 10(2) then.
So could I just pause there and say another reason why, in my submission, the Secretary of State and the IMA are right to say that is because if one looks at a case like Diaz, and this is the point we make at paragraph, I think it's 59 of the skeleton, which I've now... Yes, so paragraph 59 of the skeleton is referring to a general principle set out in Diaz, which is that it's not good to reward unlawful residents. So Diaz was quite a complicated case, but essentially it was about whether if you've been residing in a member state before the right of permanent residence was invented by the directive, could you, once the directive came into force, could you say, well, I'll have the right of permanent residence, thank you very much, because I resided here for 5 years in the past. And that passage that we've cited, and the court has it in the authorities bundle, is that unlawful residents shouldn't be rewarded. So if what you do is you reside lawfully in a member state, but then you stay there without having a right of residence, Diaz describes that as illegal residence, and the court says you shouldn't be rewarding illegal residents. So that chimes with, why should it be that if you've been in a member state but then chosen to stay there unlawfully, you don't fall within scope?
So if I look at 12(2),
so 10
one problem that you've got with this case is if we say residence was facilitated on the 12th of December 2019 because we reached the decision that he was permitted, I'll use a neutral word, I'm trying to avoid arguments about words, he was permitted to come here and permitted to stay here, then he was still here lawfully at the end of the transition period, and he was here lawfully afterwards.
Well, in my submission he wasn't, because we look back at the letter. When he
So it's the letter, you say?
Yeah, so the first, I used the letter to go more generally to the reasonable objective interpretation point, but, well no, actually I say a number of things. If you've been given an EEA family permit, if one's going to look at, well, what do you get if someone says you can go? In my submission, you certainly shouldn't do better than what you'd have done if you'd actually done things properly and got an EEA family permit. You can go, can't get you anything better, in my submission, than an EEA family permit. But suppose, for the purposes of argument, you can go means you can come for as long as you like, or you can come for a certain period. That must, at the very latest end, when he's told in terms, this isn't good enough, go apply for the right thing.
If he was any right of residence granted, must have come to an end no later than the 5th of October, because that's when he was told he needed to do something else.
At the very latest, and I would say it would have ended, or you can go, end sooner. Why should he be in a better position, for example, than someone had done what they should have done and applied for an EEA family permit?
The phase of any right of residence must have ended on the 5th of the 10th of 2020, because he was told he needed to do that in order to be able to stay.
Exactly, and that's paragraph 60 of the skeleton. In particular, paragraph 60.2.
Yeah.
So I've said that about Article 10.1a. We say Article 10.2 is the same, that if somebody's had a period of lawful residence but then decided to hang around in the member state without one, they don't benefit from Article 10.2. Now, IULA was not a case about Article 10.2, but I say you can't logically have Article 10.2 being different from Article 10.1a. But can I just show the court briefly IULA, which is at tab 18, at page 668. Facts, unfortunately, are a bit complicated, which is not ideal for 4 o'clock, I appreciate. But
take us just to the paragraph that you want,
Good,
actually.
okay.
You say it doesn't apply anyway to the facts, yeah?
Well, paragraphs 2 to 6 are the facts.
Yeah.
The court, to see what the court was deciding, see my submission captured at paragraph 65 and 66.
It sounds an uncontroversial proposal. If you had it and then you stopped having it,
Well,
then you haven't continued to reside lawfully
Mr.
thereafter.
Malik.
All you're saying is reside means reside lawfully.
At the end of the transition period. I don't think Mr. Malik agrees with that. He says that sometime in the past is good enough.
enough,
But
okay.
the upper tribunal didn't agree with that.
Right. And where's that?
So my submission is at paragraph 65 and 66. One needs just to see that to understand what the court was saying at paragraph 80. It also needs to be understood in light of the facts, because it was historic. What had happened was historic. But the passage is at paragraph 80.
So can I just make sure that, because there are two things, at the very least, he has to have been here lawfully at the end of the transition period.
Yes, that's our case.
And on the facts, that you say that's fine because of the dates. Are you also saying separately, and all residence has to be lawful thereafter, or provided you were lawfully resident at the end of the transition period, if you became unlawfully resident thereafter, it wouldn't matter?
And that
doesn't apply here anyway, does it?
It doesn't apply here, save to the extent that it was a condition of the EU settlement scheme. Now, I should just make a point that we took in our skeleton, which is that the upper tribunal obiter, in fact, makes a decision about the factual position as at 2022. We haven't accepted in our skeleton argument, see paragraph 61, that necessarily addresses whether there was membership of the household at the end of the transition period. This is a case where a lot of concerns have been expressed about credibility of evidence and so on. I think it's either the first tier or the upper tribunal makes the point that there were purportedly 4 adults living in a 2-bedroom house.
This isn't part of this appeal, though, is it?
The simple point we make is if there's a remittal, if the upper tribunal decision falls away, then the upper tribunal only made a finding as at 2022.
Oh, I see. Right, okay.
Your Lordship's judgment in Passage and Faza was that the thing presupposed that they were complying with the 2016 regs. We say that the upper tribunal obiter, I think, because it found it didn't arise, decides that there was compliance at 2022. It doesn't actually deal with the position as at the end of the transition period. It may be that rather depends on the terms of the judgment, but I just wanted to say it wasn't quite right to say we accept there was compliance as at the end of the transition period with the extended family member conditions. I think that's fair. I've also been told that I didn't say anything wrong earlier.
Oh, good.
So unless I can assist any further, those are the Secretary of State submissions.
No, I think that's been very, very helpful. A lot of these things are very complicated, hence the question. So we really, really are grateful to you and Mr. Malik.
Thank you, my Lord.
Right, Mr. Malik? Anything in reply?
Just a few matters, Lords, my lady. So my learned friend says that the residence card that you have is not an Article 10 residence card. In my respectful submission, the court should proceed on the basis that this is an Article 10 residence card.
Because?
Because if it is not, then what is it?
Well, we don't know because we're not Italians.
So, yeah, so who? I mean, that is the question, my Lord. You have a residence card that is issued by Italian authorities, which says that this is a residence card issued to a family member. It is, in my respectful submission, for the Secretary of State to establish that this isn't an Article 10 residence card, but is issued pursuant to some other domestic provision.
So we infer that it is because the language is the same and it reflects the language of the directive.
Yes.
And if the Secretary of State to establish to the contrary.
Yes, and there is no evidence, no expert evidence before you as to Italian provisions.
No, yeah.
So you proceed, as Lord Justice Lewis pointed out, we simply do not know whether why this card is issued, whether there is a Surinder Singh route, how it applies. So the court must proceed on the basis that this is an Article 10 residence card.
Yep.
The next point that my friend makes is that, well, one state that issues a residence card cannot impose that card on another state. That I accept, of course, and that does not undermine my argument. It is not my case that this card provided an automatic right to the appellant to enter the UK at his will.
They chose to accept it or validate or ratify it, yes.
That is a question for the UK, precisely, yes.
Well, decided to admit on the basis of the card. That's what they did.
Yes. So this is that is entirely yes a matter for the UK government, but no automatic right arises from it. Milan Trent took you to the directive. Milan Trent made a submission that there is no automatic right of entry under Article 5. I again accept that. No difficulty with that. There is no automatic right. It's a matter of discretion. And the real issue is that discretion was exercised. Milan-Trent took you to several authorities. The real point that Milan-Trent made was that you are not a Regulation 7.3 family member unless you have been issued with a UK residence card. Again, I accept that, of course. There's no dispute about it. It does not answer my point. Milan-Trent then makes submissions about Regulation 29. And Milan-Trent says that regulation is not about granting or refusing admission. It is simply a provision about the procedure. So that provision, as the court knows, is behind tab 4 at page 188. So this applies to a person who is claiming a right of admission, not a person who has an automatic right, but who is claiming that right, and who is in possession of a residence card, which is this person. In my respectful submission, 29.2 sets out what the immigration officer would do. What is the purpose of the examination? The purpose is to consider whether to grant the person admission or not. And if there is a grant of admission, even if the grant is on a mistaken basis, that is a valid grant of admission. Now, Millennium Trent says that this has nothing to do with granting admission or refusing it. With respect, that cannot be right, Lord, if you read Regulation 29 with Regulation 30. So if you look at 30, you'll see that that concerns refusal of admission. A refusal of admission. So a person comes to port under 29(2), the Secretary of State decides whether to grant admission or not. If the immigration officer decides to refuse admission, then 30 would apply. This regulation apply if a person has been refused admission. And why? Because the person does not meet the requirements of Regulation 11, Millennium Trent's case. Millennium Trent says that, well, Regulation 11 requirements are not met, and therefore he could not have been granted entry. And the answer is there. That is the power to refuse admission on the basis that the requirements are not met. It is, in my submission, difficult to see if there is a power to remove admission, that there isn't a power to grant admission. You asked, my Lord Lewis asked a question when Millennium Trent is making submission that, well, what is the status of the appellant following the admission? Is he here lawfully or is he here unlawfully? If I've understood the position correctly, Millennium Trent said that, well, he's here lawfully, not unlawfully.
No, I think she said he's here unlawfully.
Unlawfully.
Yeah. I think.
My apologies then. I thought she said
I think
lawfully.
I think I said he didn't have a positive right to reside, and if I didn't, but I think I gave the example of what would have happened in Mr. Chelik's case as a comparison, but I didn't.
You dodged it. What you said was you'd hope the Secretary of State would be understanding. I'm paraphrasing, but the fact of the matter is the Secretary of State has to be understanding because he's here unlawfully. Logically.
So this is this with respect is quite remarkable. C32, Regulation 30, subparagraph 2. So a person seeks admission, the immigration officer can refuse it, and the refusal makes the person unlawful resident, and the refusal means that the person then becomes subject to Schedule 2. This is immigration detention, etc. But if there isn't a refusal and there is an admission, then the person is here in the UK lawfully, being admitted by the immigration officer. Now, once he is admitted, and if the admission is by mistake, then 31 says that the immigration officer can revoke that admission as well. If a person is not entitled to be admitted, but has been admitted, then revocation would follow.
So actually 31 contemplates a situation where the Secretary of State may have got it wrong, let somebody in and realised in retrospect that that was a mistake.
Yes. So, yeah. But yes. So if the yes. So Millennium Trent says, well, mistakes are made, but if mistakes are made, this is the way to rectify a mistake, to revoke the admission, to refuse admission, as opposed to saying that, well, you've never been admitted.
I'm sorry to stand up, I haven't addressed these provisions, they weren't addressed in argument,
No.
but Regulation 31 does say a person admitted to the UK under Regulation 11, and we don't accept on these facts that the appellant was admitted under Regulation 11. We're at the moment guessing as to what may or may not have happened, but I made the submission that there's no reason to plump for the 2016 regulations over anything else, particularly as an extended family member.
So this is Regulation 29, and my submission is that this is about admission and refusing admission. And when the appellant is admitted, this is the discretion that the immigration officer exercised.
Well, actually, if you look, it says, under regulation, in circumstances, not that there's a mistake about the applicability of Regulation 11, but in circumstances where under Regulation 23(1), 2 or 3, and if you look at it, that's public policy, deportation order and so on, that's where they overlooked a bar to admission.
So, Lord, there is, not that it matters, but I'll flag this, that there is a recent judgment by this court where leave to remain was granted to someone in error.
That's YC or whatever it's called.
YC, precisely. The Secretary of State said, well, I'm taking it back. The appellant said, you don't have the power to take it back. You cannot withdraw it. This court said that there are incidental, implicit powers in the 1971 Act that is inherent to any statute of that sort. And then you can withdraw it. So assuming that 31 does not apply, there surely is a power if a person is admitted in error to withdraw it. But what 29 and 30 that together show, in my submission, is that this is about admission and refusal of admission.
Yeah.
In my respectful submission, what Millen Trent said about Regulation 11 does not answer the point that I made. So Regulation 11, page 174, Millen Trent explained why the appellant does not fall within 11.2, because he is not a family member of an EU national. It is common ground that he is not. I accept, of course, that he does not. My case, my lord, is that this provision says that if you fall under it, then a person must be admitted. But the regulation does not prohibit admission where a condition is not met. And just like YC China, there is an inherent implicit power, in my respectful submission, to admit individuals even where a condition is not met. So if I'm wrong about 29, in my respectful submission, there is an implicit incidental power under Regulation 11, which was exercised by the immigration officer.
Yeah.
Millen Trent says that a mistake was made by the immigration officer. Of course, that is her case. Now, in my respectful submission, the court should be slow to assume that a mistake was made. There is no evidence from the Secretary of State as to the practice prior to 12th of December 2019. There is no evidence that a mistake was made. How do we know that it was a mistake as opposed to an immigration officer making a decision, admitting the appellant in the UK? Millen Trent says that, Lord's Lady, you'll recall that in my opening I referred you to Section 4 of the 1971 Act. This is the provision that says that the power to grant leave shall be exercised by notice in writing. Millen Trent says that, well, the regulation also has a similar provision. In my submission, there isn't a parallel provision in the regulations. There isn't. Section 4 of the 1971 Act says that the power to grant leave shall be exercised by notice in writing. So notice in writing is the exercise of the power to grant leave. That isn't the case when it comes to admission under the regulations. Finally, Millen Trent says that word immediately should be read into Article 10(2). That means that a person must be residing, a person's residence must be facilitated immediately before the end of the transition period. You have my submission that essentially requires inserting words in the withdrawal agreement that do not exist. My other submission, Lord and ladies, is that on Vasa, when the appellant's residence was facilitated on 12th of December, it was facilitated so as long he meets the substantive requirements, so as long he remains a member of the sponsors, the brother's household. So if we reach that point, in the event that you reject everything that I've said so far, then in my respectful submission, it would be appropriate for the court to allow the appeal and remit the appeal to the upper tribunal for further fact-finding as to whether he was actually a member of the same household at the end of the transition period.
What about the argument, whatever happened in that dark day in Manchester Airport on the 12th of December, by the 20th of October 2020, it was clear that he didn't have any continuing rights to reside, because he was told he had to get some.
No. So the application that he made was the application for the new status.
Yeah.
The new status. It had no effect in my submission on the facilitation of his residence on 12th of December 2019.
Why didn't he appeal it then?
No, his residence has been facilitated. That facilitation stays in place. He was seeking to obtain something else. He was seeking to obtain the new status. The application for new status is refused. But that refusal, which isn't challenged or appealed, had no effect on the facilitation of his residence, his facilitation of his residence on 12th of December.
But if he was told, I understand that, but he still wants a new residence. That's why he's applied again.
So he's told that you're not entitled to the new status.
Yeah.
He's not told that, well, you're not entitled to reside in the UK
He's
because...
not resisting removal directions. He wants the same status that he was told 3 times he couldn't get. So he knows that whatever he's got is not intended to enable him to qualify for USS status.
Yes. Yes, but in my submission, the answer to the question that is troubling my lord is that EUSS is a new status. And the question under Article 10.2 is whether his residence was facilitated prior to the end of the transition.
I understand that, but if it was facilitated, it was facilitated at the time that he made his first application, and he didn't appeal against it, and he knew then that whatever the facilitation had occurred, it was no longer being treated, the words "you can go" were no longer being treated as sufficient to get him EUSS status. He knew that in October 2020.
Yes.
So how is it enough, given he never appealed that, to get him USS status 2 years later? Do you follow me?
Yes, in my submission, the answer has to be in the language of 10.2. The 10.2 says that, well, if your residence was facilitated prior to the end of the transition period, and you continue to reside in the UK after the transition period, you meet the 2 requirements.
No matter how many times you've been told and not appealed a decision that those don't meet the requirement.
Yes, no, because what you're being told is about the new status, something new that you're seeking to obtain.
You're told in October 2020, maybe you're told in October 2020 that which you have, whatever happened in the airport, that whatever it was, it's not enough for the new status. You're told that in October 2020. So you know in October 2020, if you want to do the new status, you've got to do something different. So why are you able to get the new status now then, without doing something different you've been told to do in October 2020?
Well, because what the Secretary, well, Lord, you have one submission that I have made. The other submission is that because what the Secretary of State was saying was plainly wrong. She was saying that you got to have a UK residence card, and a residence card is facilitation. You need that in order to qualify. But we now know for sure that residence card is not equivalent to facilitation. Residence can be facilitated in other ways. So if I'm right that his residence was actually facilitated,
Then it doesn't matter, he's been told you can't have the new status
Yes.
without doing something else.
but it doesn't
Three
matter.
decisions were wrong and you could have appealed them and you didn't, and the fact you didn't is irrelevant. You can still appeal the fourth one.
If I'm right in my primary submission, yes.
Yeah.
Very grateful.
Right, anything else? Well, you've both been very, very patient. These are not easy issues. You would think that something as basic as where do I live would be easy to answer, but as you can tell, it's not. So we are hugely grateful to both of you and to your teams, all of whom have done a great deal of work on this, and we are very, very grateful. It's complicated, so we're going to go away and think about this. We're not going to give judgment immediately. We'll do what we call reserving judgment. We want to discuss it and so on. I ought to mention, I don't know, did you know that the IMA has written to the court?
Yes, we do.
Yes.
Have you had the letter?
Yes.
Right, and we'll decide if they feel that they must say anything, and then we'll see whether or not we will allow them to say anything. I didn't know about the practice direction. Why wasn't the practice direction complied with?
It was an oversight, and we've spoken to the IMA and apologised for that. The IMA also keep an eye, but unfortunately this one slipped through the net, and we're very sorry about that.
Lots of procedural errors in this case.
I should ask, we'll send over the correct version of the 2016 regulations. Did the court need any other notes, or is that all that's
No,
needed?
I don't think we do actually. Yeah. And then we'll reserve judgment, and then in due course, I don't know whether it'll be before the end of July when we break for holiday, or whether it'll be early October, depends on commitments. We'll then send out the draft judgment in an embargoed form, which means you can only show it to the people that are allowed for the purposes for which it's allowed. And if the Secretary of State wants to show it to anybody, then they must give us names and they must give us an undertaking that each person understands the embargo. And they should start thinking about that now rather than leaving it until the hearing comes. And then it's a very serious matter if anyone discloses the draft judgment. It's a contempt of court. And then after we've had the typographical corrections, we hope you'll be able to agree in order, and if not, to make short submissions. And then there wouldn't be another court hearing. What happens these days is we hand it down electronically. We send a copy to your barrister and to the Home Secretary's barrister, and it goes on to a website called the National Archive website. So the two stages are you'll get a draft, but that's confidential and you mustn't tell anyone about it, and then you'll get the final version. Well, thank you both very much indeed, and thank you to your teams.
What around the table?